Hi everyone, Amanda Reedling again. Today I am talking about why you should not name your minor children as direct beneficiaries of your life insurance policies, retirement accounts, bank accounts, nothing, at least not in the state of Georgia. The first reason and the main reason is that it triggers what's called a minor conservatorship through the probate court. That gets triggered as soon as your child has more than $25,000 in value of assets of any kind in their name. A minor conservatorship is where you are appointed by the probate court to be a fiduciary for your child, meaning you are managing their money for them. You don't get necessarily a say in how it's spent. And as soon as your child turns 18, boom, they get it outright. It's in their own name. Doesn't matter the value, whether it's tens of thousands of dollars or millions of dollars. So that's also a downside. A 18-year-old coming into that much money at one time, especially after tragedy of losing a parent, may not be a good idea. That's maybe something for a different video, but a conservatorship or a minor conservatorship is very expensive. Not only does the conservator have to pay every year for a bond that protects the minor from you, even if you're their parent, doesn't matter, you still have to post that bond, which is hundreds, if not thousands of dollars a year of bond premiums covering and protecting decisions you may make with that money for that child. Second, you have to every year file what's called an asset management plan as well as an annual return. Sounds like something to do with taxes, but it's not. You may also have to do taxes depending on if the child earned income, but that's a different story altogether, or a different topic altogether. An asset management plan is where you tell the court, here's all the assets and money that are in this child's name. Here are the needs of the child. Here are other sources of income from the child, including support from the parent. And 9 times out of 10, the court is probably not going to give you permission to spend any of it. In Georgia, if there's still another parent living, that parent is legally responsible for that child's shelter, clothing, safety, housing, all of that. So most courts are not going to let you use that minor child's own money to pay for those things, even if that's what it was intended for, like life insurance. Let's say your spouse passes away, they have life insurance, they for some reason left it in the name of the child, and you're the one managing it for them. The courts are still going to be very strict on how much money you can spend on behalf of that child with that child's own money. So you can see how being under the purview of the court can be difficult or frustrating, or not be the intention of the funds and things like that. The cost plays into that. So, if you've never done these before, you're likely going to have an attorney's help, at least for the first year, if not after that. There are filing fees every year associated with those returns and reports. If you don't file them on time, or if you don't fill them out correctly, or if you show on there that you have spent money that you did not have specific court permission to spend, the court's going to call you in for a hearing, and they're going to ask you why they shouldn't remove you as that child's conservator and appoint somebody else, and then also probably ask you to put that money back and possibly put a civil judgment against you. So there are lots of reasons to avoid a minor conservatorship. The good news is there are things that you can do. You can create what's called a revocable living trust that is in existence during your lifetime. And instead of naming that minor child as a beneficiary or backup beneficiary, you can name that trust instead. That has the double benefit of avoiding probate as well upon your passing. I've made other videos on that, so feel free to look in the library if you're interested in how to avoid probate for other assets. Another way to do it is you can just not put your child as the beneficiary at all and have a will that says where it goes and maybe creates a trust under that will, or at least appoints an adult to manage that money for them without the need of a conservatorship and without all those filings and without the court micromanaging everything. You can actually say in your will who you want to do that and how you want that to be done. but you have to take that beneficiary off the account directly so that it gets to your will. Beneficiary designations are going to take priority over what you put in your will. It doesn't matter. So I could really go on and on about the negatives of having a minor conservatorship. In my probate practice, I've helped parents go through this. Other loved ones go through this for minors, and they're all shocked when they find out what all's involved. They're usually upset because the intention of the person that left them the asset is not carried out. This just adds to my theme of videos about why you really should talk to an experienced estate planning attorney to go through all these things, not just fill out a will and all of that, but actually look at all of your assets and look at how they're titled, look at who your beneficiaries are, and make sure it all works together. So again, thank you for listening, and I'll see you next time.